In this discussion, we're going to be talking about interrogations, false confessions, and the Fifth Amendment. An individual has the right to remain silent. Anything they say can and will be used against them in a court of law. We're going to be discussing how we got to that. Throughout the history of criminal investigations, there's always been interrogations and questions asked of suspects and witnesses, and how criminal investigators came about those answers had a lot to do with why we have the Fifth Amendment today. In ancient times, a slave that was a witness and wanted to testify about a crime, it was believed and determined that they could not even tell the truth unless there was torture. And this torture continued throughout the history of the world. First, it was in the Romans and the ancient Greeks and in Hammurabi. It was believed that a person could not be truthful or to speak the truth unless torture had been inflicted upon the witness. This moved on through the Middle Ages, and we had the gauntlet and the ordeals, and where people had to go through torture in order to be determined whether or not they were truthful, honest, and righteous in the eyes of God. As we all know, these types of interrogation and torture products will produce false confessions because people say whatever you want them to say so that the pain will stop. In American history, we had the third degree. Again, as people were being tortured through being beaten with phone books and not being allowed to sleep, and all of the things that come along with a confession, because a confession cannot be true unless it is brought about through torture. Judicial torture ended when the European courts decided that convictions did not require perfect absolute proof anymore. We no longer needed to have the confession for a conviction, but just proof that was based upon a reasonable doubt, or beyond a reasonable doubt, rather than absolute certainty. Seeking absolute truth leads logically to using torture, whether sanctioned by law or judicial procedure or not. And if the district attorney is expecting confessions and not the evidence to make the conviction, police officers are going to tend to use heavy-handed tactics. These heavy-handed tactics are defined more specifically as the third degree. In an attempt to overcome the torture of the past, even in the third degree, our founders gave us the Fifth Amendment. The Fifth Amendment reads, "No person shall be held to answer for a capital or otherwise infamous crime unless on the presentment of or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life and limb, nor shall be compelled in any criminal case to be a witness against themselves, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." There were several cases from 1791 and the approval of the Fifth Amendment up to Miranda that started to give the Fifth Amendment more and more powers and protections of the suspect in a criminal case. The final case that came to light was Miranda versus Arizona. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand these rights I have just read to you? With these rights in mind, do you wish to speak to me? These are the Miranda warnings that came out of Miranda v. Arizona. They cover the Fifth and the Sixth Amendments. And the idea was that an individual, to support the Fifth and Sixth Amendments, an individual is not to be required to be a witness against themselves, and also are required or protected with the ideas of a attorney at the start of any controversial adversarial criminal justice system. For nearly 3/4 of a century, the United States Supreme Court has evaluated confessions to determine if police interrogations met minimum constitutional standards, applying 3 constitutional provisions: the Fourth Amendment's Due Process Clause, the Fifth Amendment's privilege against self-incrimination, and the Sixth Amendment's right to the assistance of counsel. All of these came to the forefront during and through the Miranda v. Arizona case. And we looked at these 3 things in every case that came about, and it created 5 constitutional themes: autonomy, transparency, procedural fairness and regularity, equality, and accuracy. Within the autonomy portion of constitutional theme, it was believed that societies carried the burden of proving its charge against the accused, not the accused using his own mouth to convict himself. We have this theme that we are innocent until proven guilty, and it is up to the government to prove that we are guilty. Transparency is the second one, and interrogations, no matter where the interrogations are, they take place in privacy. Privacy results in secrecy. Secrecy does allow room for abuse, especially on the part of the investigator, because nobody really knows what's going on in the interrogation rooms. And however, transparency, if there was somebody else in the room with the suspect, more specifically an attorney, were present during questioning, the process would be far more transparent, and it would also be fair. And procedural fairness and regularity is also the third theme that comes about. And this philosophy, this theme ensures that even an indigent person will receive the same fairness and regularity. A rich person is entitled to an attorney, so is a poor person. And if a poor person cannot afford an attorney, one will be appointed to him. As you know, or may not know, even the free attorney that's provided at questioning during the interrogation, the cost of this attorney will be placed upon the defendant at trial if he is convicted. Equality is the next one. The due process raised concerns about the power of police and sheriffs over racial minorities. Again, equality linked to or is very the same with the procedural fairness, that everybody should receive the same opportunities to an attorney, regardless of their ability to pay for one, or their race, religion, creed, sexual orientation, or any of the other identified at-risk populations. Accuracy is the last one, and accuracy has transcended common law. It's now where we see videotaping of interrogations, we have tape recordings of interrogations, and this ensures that the accuracy of the report that's being brought to the courts is beyond reproach. Since 1966 and the ruling in Miranda v. Arizona, The court has severely weakened the Miranda rule, holding that if a suspect makes confessions in an interrogation that's violated Miranda rules, a subsequent confession taken from an interrogation in which Miranda warnings were properly read and administered is admissible in court. They also stated that the fruits of the poisonous tree doctrine, where any evidence that is obtained through an unconstitutional act on the part of the police, is exempt from confessions and interrogations. Those interrogations and those confessions that are taken, even if it violates Miranda, are admissible in a court of law.